A trial going on in Madison challenges the way Republican leaders redrew legislative districts. The suit, filed by Democrats, claims Republicans drew the lines to keep themselves in power for a decade. An attorney representing the Democrats called it one of the worst gerrymanders in modern American history. The lawsuit could have important political ramifications, and we're talking about all of this now with J.R. Ross, editor at WizPolitics.com, our editorial partner. He's at our Madison affiliate, WKOW-TV. J.R., good to have you back on the program. And these legislative maps have been challenged before, but this is a different kind of challenge. How so?
This one is purely partisan, basically the foundation of it. If you go back, this map itself has been challenged before on representation for Latino voters in the Milwaukee area. They moved a line to ensure adequate representation, so that's something we see often. This one, though, is purely partisan. Basically, they're saying that you've gone too far with this map, Republicans, and have made it so partisan that it's unfair and unconstitutional. And that's the crux of the case. It's unique in that we don't often see these kind of cases go this far, and we haven't really seen a line drawn before by the courts of what is too partisan.
Mm-hmm. And you have said to me, JR, that this may come down to something called the efficiency gap. What does that mean? What is the efficiency gap?
Essentially, it's number of wasted votes in an election that either because of what they call packing or cracking. Packing is essentially you take a bunch of voters from one party or the other and pack them into a district. For example, Milwaukee, you have very, very partisan districts in Milwaukee because there are a lot of Democrats who live there. They're 85, 90% Democratic. That's a district that some would argue would be packed. Cracking is diluting the number of voters from a certain party in a district to the point where they can't win. That's kind of the crux of it, and they're saying essentially that you have wasted votes from Democrats to the point that even though Democrats win statewide in Wisconsin, for example, in 2012 by a large margin, they still came back with 39 seats in the assembly. Why is that happening? Their argument is because the map is not proper.
What are the attorneys representing the state saying about these maps? How do they defend them?
Basically saying that it's nothing new. I mean, if you think about it, gerrymandering goes back to 1812. The term comes from a Governor Gerry in Massachusetts who signed a map that had a district look like a salamander. So we're used to seeing districts drawn for various reasons. And they're saying, look, Democrats are packed in districts in Milwaukee because that's where Democrats live. It's nothing unusual about that. What's unique here, the thrust here is that the U.S. Supreme Court, in past cases, you've had basically 4 justices saying there's no line whatsoever. They can go as far as they want for partisan reasons and they're fine. You've had 4 justices in the past say, well, actually, there is a line that they can cross and it's too far. And you've had Justice Kennedy, who people are going to watch in this case, have said, well, there could be a line, I'm just not sure where it is. And what's unique here is this case is trying to argue a 3-pronged test, if you will. One of it is the efficiency gap, the metric, if you will, that you can cross this line, and that's a problem. A second one is intent. Not just that it was a partisan map, that it was so partisan to create a durable gerrymander, if you will, that would last for years. And the third one is there's no other justification for it. There are requirements, for example, under U.S. law that you have to have adequate minority representation in districts. You may have to draw an oddly shaped district to meet that requirement. You can justify the map in that way. That would be the 3-pronged test. When the state says, look, there's nothing unusual about these maps. These lines don't look crazy. There's not a salamander-type district, if you will, in the Wisconsin map that would make this look unusual, and therefore there's no basis for the lawsuit.
Briefly, JR, when could we expect a ruling in this, and what are the potential ramifications of it?
Good question. There's a 3-judge panel in Madison that's heard the case. If it rules in favor of the plaintiffs, there could be an appeal to the U.S. Supreme Court, which would take it up directly. There's a big timing crunch here, remember. I think the plaintiffs want the maps run out now, but you have June 1st as the deadline to file nomination papers, August 9th as a primary. You're talking, if they did have to do this, redraw the lines, it'd be a huge time crunch and could create chaos in the assembly, at least, between now and August 9th the primary is.
All right, J.R. Ross, the editor of WizPolitics.com, our editorial partner, joining us on the satellite from Madison. J.R., thanks very much for being with us.
Anytime.
When we come back, the final battleground in Wisconsin.